Good afternoon, everyone. This is Saloni, Assistant Professor, IIMT College of Law, Greater Noida. Today, I'm going to speak on the topic of law of agency. Coming to the first part of our topic, introduction. What is agency? Where one party delegates some authority to another party, whereby the latter performs his action in more or less independent fashion on behalf of the first party. The relationship between them is called an agency. So, as per the introduction of the topic, agency is a relation between two persons wherein one person is an authority to give express orders to the another person who is commonly known as agent. Agency can be express or implied. Chapter 10 of the Indian Contract Act 1872 deals with the laws related to agency. It is important to know the law relating to agency because nearly all business transactions worldwide are carried out through agency. All corporations, big or small, carry their work through agency. Therefore, laws relating to the agency are an important area of business. Relationships related to principal and agent involve three main parties, that is, number one, the principal, the agent, and the third party. So, in the very general language, agency is a relation between two persons, whereas one party delegates some work or some authority to another party, wherein the party delegating the work is known as the principal, and to whom the work has been assigned is known as the agent. In this relation of agency, the agent is bound to listen to the principal and carry on all the acts according to the wishes of the principal. Agency is being defined under section 182 of the Indian Contract Act 1872. It is important to know that the law related to agency because nearly all the business transactions worldwide, as we see in important business dealings, it's not necessary that a person joins every communication by himself. When the work is spread to a very large extent, the agent has been appointed usually by people who represent such person in the business dealings of that person. So coming to the first point, what do you mean by an agent? Who is an agent? The Indian Contract Act 1872 defines an agent in section 182 as a person employed to do an act for another or to represent another in dealing with the third persons. Secondly, who is principal? According to section 182, the person for whom such act is done or who is so represented is called the principal. Therefore, the person who has delegated his authority will be the principal. So, considering these 2 points, we can say that agent is a person who is employed to do an act, who is subsidiary, who is below the principal, and who follows the orders of the principal. Whereas principal is a person on whose behalf the work is done, who delegates his authority to the agent is known as the principal. For example, a businessman delegates B to buy some goods on his behalf. Here, A is the principal and B is the agent, and the person from whom the goods are bought is the third person. Secondly, Joey appoints Mary to deal with his bank transactions. In this case, Joey is the principal, Mary is the agent, and the bank is the third party. Third example, Lavanya lives in Mumbai but owns a shop in Delhi. She appoints a person, Suzanne, to take care of the dealings of the shop. In this case, Lavanya has delegated her authority to Suzanne and she becomes a principal while Suzanne becomes an agent. So, considering all these examples, we can conclude that where a person appoints another person to act on his behalf, such person is known as a principal, and the person so appointed is the agent, and with whom they both are all together communicating is the third party. Next, who can appoint an agent? So basically, for every contract under Indian law, there must be the eligibility to become to get into a contract. Similarly, under the contract of agency, according to section 183, any person who has attained the age of majority and a sound mind can appoint an agent. In other words, any person capable of contracting can legally appoint an agent. Minors and persons of unsound mind cannot appoint an agent. Who may be an agent? So first, in this initial part, we consider that who can appoint an agent. So any person who is minor and who is of sound mind can easily appoint an agent to act on his behalf. Second, who may be an agent? So again, agent can, according to section 183, a person who has attained the age of majority and has a sound mind can become an agent. Similar criteria like that of the principal. A sound mind and a mature age is a necessity because an agent has to be answerable to the principal. Age, you cannot appoint a child as an agent, and even if you appoint any child as an agent, he will not be responsible to you. He is not so mature to act on a behalf, and even if he does, he will not be held responsible. Next, creation of agency. If we come to the point that how agency is created, what after two people get into the relation of agency, the following criteria, the following modes of creation of agency are described. An agency can be created by number one, direct express appointment. The standard form of creating an agency is by direct appointment. When a person in writing or speech appoints another person as his agent, an agency is created between the two. So when a person directly, whether by written or by orally, he appoints another person as an agent, the agency is created between the two. Second, by implication. Agency when created by implied manner. When an agent is not directly appointed, but his appointment can be inferred from the circumstances, an agency by implication is created. Third, necessity. In a situation of necessity, one person can act on behalf of another to save the person from any loss or damage without expressly being appointed as an agent. This creates an agency out of necessity. So, when there is any sort of emergency wherein one person acts on behalf of the another to save such person from any loss or damage without being expressly appointed, where the person does not expressly appoint a person as an agent, but any third person does any act to prevent that person from any loss or damage, it creates the agency out of necessity. Fourth, estoppel. An agency can also be created by estoppel. In a situation where one person behaves in such a manner in front of a third person as to make someone believe he is an authorized agent on behalf of someone, an agency by estoppel is created. Lastly, ratification, where an act of a person who acted as an another person's agent on his behalf without his knowledge is later ratified by that person. This creates an agency by ratification between the two. So when a person does an act on behalf of the another person, but the person is not knowing that such act is done on his behalf, but later on, upon knowing this fact, he agrees with such act. He ratifies that act. This creates an agency by ratification between the two. Coming to next, after the modes of creation of agency, we will discuss upon the topic that how many types of agents are there. So number one, there are special agents. Second, general agent. Third, sub agent, co-agent, and there are other forms under the mercantile law, naming factor, broker, auctioneer, commission agent, and del cadre. Coming to the first one, that is special agent, an agent appointed to do a singular specific act, where person A appoints person B as his agent for any specific particular work. Suppose he appoints a person only to load and unload his goods from the ship or to load his goods into the ship. The agent so appointed is known as special agent for a singular specific act. Secondly, general agent, an agent appointed to do all acts relating to a specific job. He is given the responsibility of many other work to be done on behalf of the principal. Third, sub-agent, an agent appointed by an agent. So there are many acts where the agent needs a sub-agent, and hence he appoints, obviously after considering all the requirements with the principal, he appoints another person as a sub-agent, and that sub-agent is responsible directly to the agent and not to the principal. Fourth, co-agent. Agents together appointed to do an act jointly. Co-agents means when there are multiple agents who will be doing work with each other in together manner. Fifth factor, an agent who is remunerated by a commission, one who looks like the apparent owner of the things concerned. So factor is the agent who's remunerated by a commission. Daily basis commission is being paid to him for doing any work which has been authorized to him. Sixth is broker, an agent whose job is to create a contractual relation between the two parties. So broker is something that we have heard many a times in our daily interactions. Broker is a person who creates a job between the buyer and the seller. Broker is a person who creates a relationship between two persons who agree to enter into a contract. Broker is a person who maintains a contractual relationship between the two parties. Seventh, auctioneer, an agent who acts as a seller for the principal in an auction. So auctioneer, in the very simple terms, I would say, is the person who conducts an auction, is the person जो नीलामी करवाता है. So auctioneer is a person नीलामी करवाने वाला. An act is done by the agent on behalf of the principal, wherein under the principal he is authorized to sell anything in an auction, and such person is called as auctioneer. Commission agent, an agent appointed to buy and sell goods, make the best purchase for his principal. Many a times principal cannot do every work uh, to which he is the master by himself. For this, he appoints a commission agent. So, commission agent is usually done in the transactions where there is a purchase and sale. Similarly, when there are shop owners, they cannot leave the shop and go and buy goods or sell out their goods in the market other than their shop. So they appoint a commission agent who further goes to other areas and sell the goods of the shop to people, and similarly interact with the people to maintain a clientele. Ninth is delegatory, an agent who acts as a salesperson, broker, guarantor for the principal. He guarantees the credit extended to the buyer. So, delegatory is a person who assures that all the credit given by the buyer to any third person is returned back to him. He guarantees the credit extended to the buyer. So, whatever goods, whatever thing, whatever money the seller has paid to the buyer, he ensures that the buyer returns such goods or money accordingly within the reasonable period of time. Coming next, it is a bit critical point, because under the Indian law, husband and wife are treated as one entity. They represent each other altogether, and they are not considered as different entities. Therefore, we will discuss agency between husband and wife in this topic. Generally, there exists no agency between husband and wife, except in cases where it has expressly or impliedly been sanctioned that either of them would do certain acts or transactions as an agent of the another. So, husband and wife are not the agent of the other. Wife do not represent the husband in the transactions, and the husband do not represent the wife in any other form of transactions. But there are cases wherein they may act as a wife, as the agent of each other. They are such conditions are expressly or impliedly being held out, that that they would act as an agent of each other and do certain acts in this relation. That is, a relation of agency can come into existence between the two through contract, appointment, or ratification. Next, a husband is responsible for the necessary of his wife when they are living apart due to his husband's fault. So when the husband and wife is living together, and it is due to the fault of the husband is responsible for the necessaries to be supplied to his wife if they are living apart. This results in an agency of necessity where the wife can use her husband's credit for whatever is necessary for her to live. But in cases where they are separated because of wife's own bad conduct, whims or faults, for no other reason, the husband is not liable for the wife's necessity. So generally, husband and wife act as the agent of another under this Indian Contract Act, and the husband, in lieu of this, the husband is bound to provide necessaries to his wife when they are living apart, on the fact that the husband has been at fault. Sub-agent. Earlier, we have read this term sub-agent. Sub-agent is defined under Section 191 of the Indian Contract Act 1872. Coming to the definition, an agent may sometimes delegate the duty that has been delegated to him by the principal to somebody else. Ordinarily, an agent cannot delegate the duty he is supposed to perform himself to another person, except in particular circumstances where he must, out of necessity, do so. So, according to the general rule, if an agent is given a certain kind of duty, he needs to fulfill it by himself only. He cannot authorize this agency to any further person and get the work done. Similarly, when an agent appoints a sub-agent, it breaches this general principle. If all the acts are supposed to be done by the agent, then why there is an appointment of sub-agent? Some agent would clearly amount to violation of the general rule. So sub-agent is the agent that is appointed by the first agent, who, seeing the criteria and eligibility of the new agent, appoints him. Ordinary agent cannot delegate the duty, but while he appoints a sub-agent, he can tell the sub-agent to do a certain kind of work and get it paid, and get him paid. There is a legal maxim meaning delegatus non potest delegere. So you cannot delegate what has been delegated to you. Usually we say that if a certain work is assigned to you, you must perform that work. You are responsible for the performance of that work, not anybody else. Similarly, under the contract of agency, the agent is responsible for every work. But as per the exception rule, a sub-agent can be appointed by him for his ease and for the distribution of business. So what this term delegatus non potest delegere? An agent cannot, in ordinary circumstance, delegate the duty that was delegated to him. So what duty has been given to me, I cannot just tell any other person to do that duty. The principle is based upon the idea that when a principal appoints an agent, he does so by placing in confidence and trust in the agent and might not have a similar trust in the work of the another person. So sub-agent is a agent who is appointed by the agent with after seeing all the conditions to which he is suitable to. And this principle is based on the idea that when the principal appoints an agent, he does so by placing his confidence and trust in the agent and might not have a similar trust in the work of another person. So sub agent is largely based on the mutual trust and confidence. Coming to the next part, there is section 194, which states substituted agent. So who is a substituted agent? Sub-agent has been the agent who is below the agent, but substituted agent is appointed for some specific purpose. He substitutes the agent, does that work and goes away, and then agent again becomes the agent of the principal. The difference between the sub-agent and the substituted agent is very fundamental. When a person in the capacity of an agent is asked to name some person for a task, the person who is named does not become a sub-agent to the principal, but a substituted agent. So this section says that when the agent is appointed but by the principal, then such agent is known as substituted agent, and for some task he is appointed. Illustration: Sarah asks her solicitor to appoint an auctioneer to sell her antique merchandise. Her solicitor appoints Naz as an auctioneer. In this case, Naz is not a sub-agent but is in fact a substituted agent for the firm. So he appoints solicitor for Naz as an auctioneer. Auctioneer cannot be termed as the agent, but he is only a substituted agent for a while and not for a very long time. Coming to the next point, agency by ratification. So what is ratification? Ratification is the correction of things by going into the past, or the things that have been done in the past is further ratified. The principal may subsequently ratify an act done by a person who acted on this behalf without his permission or knowledge. If the act is ratified, a relationship of the agency will come into existence and it will be as if had been previously authorized the person to act his agent. Ratification may be expressed by speech or writing or implied by an act of the conduct. Coming to the illustration part, Steve bought apples on behalf of Mark without his knowledge or permission. Mark sold those apples to another person. This mark of act of Mark implies ratifies the purchase made by Steve. So in this illustration, it is said that the Steve bought apples on behalf of the Mark without the permission. Mark did not ask to buy such apples, but later on sold those apples to another person. This act of Mark impliedly ratified the purchase made by the Steve. There are few cases, few exceptional conditions where ratification is not allowed in the following cases. When a person's knowledge of the fact of the case is defective, that is, he only knows things that is ratifying to. So ratification cannot be allowed when the person himself is not interested in the subject in agency. When he himself is so free that he do not give consent to any further act, then ratification cannot be allowed. That is, he only knows the things that he is ratifying to. He does not know the further consequences. An act on behalf of another person which would have effect of injuring or harming the person or violating any other rights if the act was done with authority. An act on behalf of another person which would have the effect of injuring or harming the person or violating of any right if the act done was done with authority. So ratification cannot be allowed under these two cases. Coming next, what is termination of agency? So if we see, agency can be terminated by the acts of the parties or by the operation of law. What do you mean by acts of the parties? It means that the party themselves want to end the contract of agency. Whereas operation of law, that the parties are not necessarily willing to end the agency relationship, but there are conditions that by law it needs to be terminated. The court or the bank is held with the responsibility to terminate this agency wherein the both the parties are not ready to have such kind of relationship. There are various forms and various conditions when agency can be terminated or is terminated in 5 different ways. When the agent's authority is revoked by the principal. So when the principal himself says that you have done the work, now you can move, now you can leave this work and go, then it can be terminated. Second, when the agent renounces the business of the agency. जब एजेंट खुद से ही वो बिजनेस ऑफ एजेंसी को खत्म कर दे तो कहते हैं कि इट इज रिवोक्ड बाय द प्रिंसिपल. It's revoked by the principal and the agent renounces the business of the firm. When the business of the agent is completed, when the business about whatever transactions the parties had in between, it comes to an end. When either of the parties dies or become mentally stable. So it states that when the party, both anyone, the principal or the agent or the master or the servant, either of the parties dies or become mentally disabled, then you cannot get into the relationship of agency, and what is left is termination of agency. When the person is adjudicated and insolvent. So adjudicated as insolvent means that he has been left with no money and he is bankrupt. He do not have any sort of money, so that is known as adjudicated as insolvent. Next, revocation of agent's authority. There are certain rules regarding the revocation of agent's authority. It can be revoked at any time before the authority has been exercised. If according to the principle of the contract between the two, the agency has to be continued up to a certain time, any prior revocation by the principal shall be compensated to. The termination does not take effect because it has been communicated to the agent. Termination of the authority of an agent terminates the authority of the sub-agent. So basically, what do you mean by revocation? Revocation is ending the agency principle. There are certain rules regarding revocation. It can be revoked anytime before the authority has been exercised. So even if you do not have exercised anything, you have not exercised any relationship of as an agent, but the agency has to continue up to a certain period of time, and there are people who are left with such revocation. The discretion is with the principal, who allows the agent to get removed from his post. Any prior revocation by the principal shall be compensated for to the agent. The termination does not take effect because it has been communicated to the agent. Termination of the authority of agency terminates the authority of all sub-agents. This line is very essential. It must be remembered that when an agent is terminated, all the sub-agents that he appointed also needs to be terminated all together with the agent. Agent's duty to principal. Agent has 6 duties towards his principal. Number one, he has to conduct the business of the principal according to the directions of the principal. So, what are the agents? To do the work as given by the agent. An agent is bound to conduct the business he is supposed to conduct with as much skill as a person on his position ordinarily holds. An agent is supposed to show the relevant accounts to the principal as and when the principal demands. An agent has a duty to communicate any difficulty, whatever he may come across, while doing the principal's business. He is supposed to perform due diligence in his regard. Any material fact that has been concealed or the business is not carried out in the manner that the principal directed, the principal can repudiate the contract between them. If the agent carries out the business in the manner he wanted to perform, rather than on the direction of the principal may claim from the agent any benefit he may have achieved doing such work. So there are altogether 6 duties. There might be additional duties of the agent, but conclusively there are 6 major duties of an agent, which had been discussed in this part of the lecture. Similarly, on the other side, there are other duties which the principal needs to follow against the agent. So number one, the principal is bound to indemnify the agent against any lawful act done by him in the exercise of his authority as an agent. So meaning, when the agent has done any wrong during his term as an agent, the principal is bound to indemnify. Means to protect the agent from any loss or damage which has been incurred by him. Second, the principal is bound to indemnify the agent against any act done by him in good faith, even if ended up violating the rights of the third party. So, even if the work is done in good faith, the principal is bound to indemnify the agent against any wrongful act. Third, the principal is not liable to the agent if the act that is delegated is criminal in nature. So, there, under the Indian law, there is an exception of criminality in every subject. Similarly, if the agent has done anything which is criminal in nature, the principal cannot be made liable for his act of criminal offense. The agent will also, in no circumstance, be indemnified against criminal acts. Lastly, the principal must make compensation to his agent if he causes any injury to him because of his own competence or lack of skill. So, if the principal if the agent does anything because of his lack of competence or he was not doing something, the principal must pay compensation to the agent. Coming to the conclusion, we need to revise all the things that have been read earlier in this lecture. So we read about what is agency, how the agency is created, who is an agent, who is the principal, termination of agency, revocation of agency, and the requirements of forming the relation of agency. Concluding my point, I would say contracts establishing a relationship of the agency are very common in business law. These can be expressed or implied. An agency is created when a person delegates his authority to another person, that is, appoints them to do some specific job or a number of them in specified areas of work. Establishment of a principal-agent relationship confers rights and duties upon both the parties. There are various examples of such relationship. Number one, insurance agency, advertising agency, travel agency, factors, brokers, telecadre agent, etc. So there are various modes of agency, and it occupies it consists of various professions. For example, travel agency, factors, brokers, advertising agency, all these things. So, concluding my lecture, I would say that this lecture has been very exhaustive and informative for everyone who needs to prepare any topic in the Indian Contract Act, specifically the law of agency. I would like to give the conclusion to my lecture and would like to say thank you to all my viewers. Thank you.